Welcome to GovCon Essentials and Teaming. We're going to be getting started right at the top of the hour, so we are really super glad that you're here. I'm Judy Bratt, and we're going to be going through ways to be teaming successfully in the federal market in just 2 minutes. So hang on to your hats, get your questions ready, and we're going to be here to help you. If we can't answer your questions in real time during the event, then for sure we'll be able to get to them afterward. So you'll be able to contact me. We'll have bonuses. You're going to get a copy of this recording afterward, and we're so glad that you're joining us today. Heather Herbine is our moderator. I'll introduce her in just a moment, and we'll get started in just a moment. So stick with us, and we'll get this thing done. I am Judy Bratt. We're just a couple of minutes from the start. We'll be introducing our panelist, our moderator, getting to your questions, all about teaming essentials in the federal market. Welcome. We're really glad you're here. We've got people logging on from all over the country for ways to be more successful in the federal market. That's what we're here to bring you. And it's the start of the hour. Welcome. One second. And alrighty. Got it. Okay. Hey, well, welcome to our GovCon webinar, Teaming Essentials for Success with Maria Panichelli. My name is Judy Bratt. I'm CEO of Summit Insight, and we are here to bring you our best in how to be successful in the federal market. Today, our focus is all about teaming, and what we're going to do is bring you tips and success from a nationally recognized speaker and let you have the chance to bring your questions. This webinar is being recorded. You're going to get a copy of this recording within 24 hours of the close of the session. And so with that, I'm Judy Bratt, CEO of Summit Insight, and we're the host of this GovCon webinar series. A special welcome to you who I'm meeting for the first time. I'm so glad you're here. If this is your first webinar, please drop the number 1 in the chat so I can see you and give you a special welcome. Summit Insight is a professional services firm. For you, and I hope for us, marketing and sales are acts of service, which is why I bring you this webinar series. You can find out whether you're a fit to work with us and get free links to great resources along with my book and my workbook just before Q&A when we wrap up. Heather Herbine, co-founder of Transcendent Marketing, is our moderator today. Marketing Masters combine best practices and tested methodologies for your one-stop shop for all things sales and marketing, from digital and social to cold calling and CRM and management. The company founders each have over 15 years experience in opening doors in the federal arena with key players to help their clients bring home millions doing business with the people you want to connect with. Here's what we're going to cover: differences between teaming, joint venturing, the SBA mentor-protege programs, and when to use each. Differences between subcontracting and teaming, strategies for forming a successful team, most important provisions in a teaming agreement, enforceability expectations and exclusivity and how they can impact your team, how teaming can go wrong and the negative consequences, and common pitfalls and how to avoid them. Here's how to participate. Please make active use of the chat box. Raise a hand, unmute for live Q&A if you have the opportunity, and book a follow-up call with me or with our guest at the end. Watch your email by close of business tomorrow for the recording if you're here live, and please contact us when you've got other questions. Get out your notebook. Finally, you're going to take action. At the end, I'm going to ask you, what one thing are you going to do that's different as a result, and by when, based on what you learned? If you have questions, drop them in the chat as we go along. If we can't answer them live, we will get to them afterward. Heather, talk about the poll for just a minute. Why do we do it, and How do they do, and how do they participate?
We'll be launching a live poll, and really what it's designed to do is to help us better understand who we're serving and serve your needs better in the future. So if you could just, it's a 5 question poll. If you could fill it out and participate, that helps us work with you better in the future. So thanks.
Thanks so much. So, with that, Teaming Essentials for Success is being presented today by my friend, Maria Panichelli. Let me just tell you a little bit about Maria. Um, she has been, and for many, many years, an expert in federal contracting. She is partner and chair of the government contracting department at the law firm of Obermeyer, Redmond, Maxwell, and Hippel. She focuses her practice exclusively on federal contracting and procurement, guiding her clients through the entire procurement lifecycle of their federal contracts. Maria has represented her contacts and clients through numerous federal agencies, including Government Accountability Office, Contract Board of Appeals, Court of Federal Claims, and the U.S. Court of Appeals for the Federal Circuit and other state and federal courts. Her practices areas include bid protests, claims, performance and compliance, counseling, subcontracting and subprime dispute resolution, pass-through claims and liquidating agreements, and small business procurement, including eligibility and certification issues, size and status protests, teaming, joint ventures, and the mentor protege programs. Maria's clients include prime contractors and subcontractors of all sizes in this country and abroad, covering a full swath of federal agencies and industries. She's a frequent lecturer and author on federal procurement and small business related topics, and she's thrilled to be partnering with us today to deliver quality educational content to federal contractors. Maria, take it away.
Thank you so much, Judy, and thanks to everyone out there for joining us today. As Judy said, my name is Maria Panichelli. I am a partner and the chair of the government contracting group at the law firm of Obermeyer, Redmond, Maxwell, and Hippel. Obermeyer is a full service law firm. It's got over 100 attorneys, and we've been around for over 100 years. So we do everything from tax law to employment law to family law, you name it. We've got attorneys that probably do it. But my group, the Federal Government Contracting Group, focuses exclusively on federal government contracting, which means that's all I do all day, every day. That's the entirety of my practice is helping government contractors navigate the complex web of procedures and regulations that they need to navigate to be successful in the government contracting industry. As Judy said, I cover kind of a broad spectrum of different services, REA, claims, bid protests, different compliance aspects. But what we're going to be talking about today is a big piece of my practice under the small business procurement umbrella. And that is specifically the perennial favorites of teaming joint venture and the mentor protege programs. So where I'd like to start is with the building blocks. Many of you have probably already understood or heard and believe you understand about some of these concepts. Lots of people talk about teaming, lots of people talk about joint venturing. You might have heard the mentor protege programs or, now mentor protege program, and we'll get to that in a little bit, thrown up in the mix. But what I have found about teaming and joint ventures is that a lot of people know just enough to be dangerous because unfortunately the regulations governing this area are really complex. And if you know even 9/10 of them, that one might throw you out into the doghouse. It's really important to know everything that's out there, kind of know how all the moving pieces fit together. Be very, very reluctant to trust information you get online, mostly because the regulations have changed so much and the related regulations have changed so much in recent years that you can really get yourself into trouble, even relying on a blog article from someone like myself who deals with this stuff that's even 6 months out of date because the regulations might have changed and you might be in a completely different situation than you would have been otherwise. So I like to start with the building blocks, kind of the foundational principles that you need to know, because even the most sophisticated of contractors, whenever I do presentations like this, I generally find that a couple of them come up to me afterwards and say, wow, I've been doing this for years and I didn't know that one thing. And it might be, yep, that's kind of buried in the regs, or it might be, yeah, that's new from last fall. But very important to start with the building blocks. Make sure that you're kind of understanding the conceptual framework and then build upon it from there. So the first thing I want to talk about is the lingo, how to talk the talk here. You will sometimes hear the term teaming or the terminology teaming used as kind of an umbrella term meant to encompass any sort of relationship between contractors when they're talking about, performing in conjunction on a federal project. But strictly speaking, that's not correct. I would say partnering or cooperating or some sort of partnership agreement in terms of, how you're going to work together. But teaming is a very specific type of agreement. Specifically, it is a special type of subcontracting that two companies agree to at a point prior, usually, to submitting their bid or their proposal on a specific job. So it's a specific type of subcontracting relationship, which means that unlike joint ventures, which we'll get to in just a second, you still have one company that is functioning as a prime and a second separate individual company that's functioning as a subcontractor. And then there's a subcontract between them. Now, when you are talking about the difference between subcontracting and teaming, the difference is that when you team, you put together your teaming agreement, which is kind of an agreement that you're going to enter into a subcontract early in the process. So, what do I mean by that? I mean, instead of waiting until you get your contract from the government and then saying, okay, we got, some proposals from subs when we were putting our own bid or our own proposal together. Let's go back to the one that, whose proposal or bid made the most sense, and let's enter into a subcontract agreement with them now. What you do when you're teaming is much earlier in the process, before you even submit your bid or your proposal to the government. You get together with your teaming partner and you say, okay, let's work together on this bid or proposal. The idea being that if you, or, let's say you're functioning as the prime contractor, if you get the contract from the government, you will in turn give a subcontract to that teaming partner. The idea is, as the small business, because we're talking about using these strategies for set aside contracts, and we'll talk about that a little bit more in just a second. But the idea is that you, as a small business, have the eligibility for a set aside contract, and you can leverage your eligibility. But at the same time, because your teaming partner is going to be on board prior to putting together your bid or proposal, you can leverage their capabilities as part of that bid or proposal, hopefully giving you a competitive leg up. So what I mean by that is, okay, we've got a set aside contract. You're a small business that has access to the set aside contract because you are a small business. You've got the eligibility. You are dealing with a set aside contract where only small businesses can compete. The large business can't get their foot in the door for that, right? You can. But where might you have some, room for improvement? Maybe because you're small, you haven't had as much past performance. Maybe you don't have as deep a bench of, experienced employees. Maybe you don't have the capabilities to bond bigger jobs if you're in construction, things such as that. That's where your large business teaming partner comes into play. That's where you can leverage their capabilities and you kind of team up early in the process and you say, let's work on this bid or proposal together so that the government sees that, not only am I great, but my teaming partner is great. So they're going to have a great team working on this project. And then if you get the award, you enter into a subcontract. And we're going to talk about best practices and, maybe having a subcontract drafted early in the process a little bit later. But that's what teaming is. That's how it's different than subcontracting because you do it earlier. And now let's talk about how it's different than joint venturing. Like I said, teaming, special type of subcontracting relationship. You still have one party in the set aside context. It's going to be the small business party that has a contract or is in privity of contract with the government. And then a second company that has a subcontract to that prime. Joint ventures are a little bit different. Joint ventures are when two or more companies come together and those companies form a joint venture. The joint venture is then the prime contractor. So it's not, two companies staying separate and, one is a sub and one is a prime. The joint venture is now competing as a joint venture for the prime contract award. Now, sometimes the joint venture will then enter into subcontracts with each of its joint venture partners. Obviously, that's a little bit more of an advanced strategy that, if you have questions about, we can talk about online. Feel free to reach out to me. But that is the difference, the primary difference between teaming and joint venturing, and kind of a number of differences or considerations, as we're going to talk about as we go forward, flow from that primary, difference in framework or difference in setup. It's also important to keep in mind that CTAs are a little bit different than teaming agreements. CTAs are a specific type of, partnership agreement or cooperative agreement under GSA contracts, and those are outside the scope of what we're going to be talking about today, but it makes sense to be aware of them and be aware of how they are distinguished from regular teaming agreements. So all of that being said, you might be wondering, how does the mentor protege fit in the mix? The mentor protege programs that the SBA had in place and now have, is working on consolidating into one. The reason that this becomes an issue is that because, when you're dealing with teaming, you've got the small business as the prime, and we talked about them having the eligibility. When you've got the joint venture going after a set aside contract, the joint venture needs to jump through certain hoops in order for the joint venture to be considered small. So if one of the joint venture partners is considered small, obviously you've got the capability, or you've got the possibility rather, excuse me, to try to set that joint venture up in a way where it is also small and can go after set aside contracts. Same thing if you're talking about, a hub zone or an 8A or a woman to own, joint venture, or I'm sorry, a company that is partner to the joint venture. Then you can start working towards, okay, where can I go and what can I do to get my joint venture eligible for these set aside contracts? If your joint venture is in between a small company and a large company, a company that itself is not going to fall under the applicable NAICS code size standard, that is why mentor protege comes into the mix, because that is why, when the mentor protege program and becoming approved in the mentor protege program becomes a prerequisite to having your joint venture set up in such a way where it can be small. And we're going to talk about that more as we go forward in more detail. But just to kind of give you an idea, like I said, we're going over the basic building blocks. Now you know the differences between teaming and joint venture. You know why mentor protege is usually lumped in with these two topics when you're talking about it. Specifically, that's because it can be a prerequisite to forming a joint venture that's eligible to go after set asides. Next slide, please.
Maria, someone asked, what is a CTA, which you mentioned in the third bullet of the first section?
So a CTA, technically the terminology is contractor teaming agreement, but it's different than the type of teaming agreements we're going to talk about today. Again, they're the ones that are used specifically when you're dealing with GSA contracts. And there's a little bit different formula and thought process and analysis that goes into them. So, for our purposes here today, they're outside the scope of what we're going to be talking about, but it's important that contractors remain aware and that they not confuse the terminology, because if you're trying to put together a CTA, it's not necessarily going to be the same concerns we're talking about today.
So if someone wants to know more about CTAs, they could contact you. Yes?
Absolutely, yes.
Okay, great.
All right, so now that we've kind of talked about the differences between them, the differences between these strategies, what contractors need to do is think about which one makes sense for me on any given project or at any given time. And obviously this is going to tie in, a lot with the kind of help that Judy can give you in terms of, looking ahead. What are my strategies? How do I market to the government? What opportunities am I going after? And what's the best way to go after them? And the things you need to think about when figuring out, what your strategy is and what you're going to go after, and whether it makes sense to team up with a great other company that you've just been introduced to, or whether it makes sense to form a joint venture with that company, are, there's myriad concerns. Some of the overarching, I guess, bullet points or headlines. You obviously want to think about your own goals, the strengths of your company, the weaknesses of your company, where you're really, really great, where you have room to improve, honest assessment of what your capabilities are and where you could use maybe some buttressing or some help from other people. And then you want to do the same assessment of your partner's goals. The goals, strengths, weaknesses, capabilities, where they could use a little help, where they would be well positioned to give you help, where you could perhaps, benefit from their tutelage or their mentoring once you get into the mentor protege program. You really want to think in terms of reality. Obviously, you want to be optimistic. Obviously, you want to make sure that you're going in with a positive attitude, but it is also very important to go in with a realistic expectation. Think about any time you ever worked on a group project in your life, back when you were in middle school or high school. Think about if somebody overpromised and didn't deliver, the position that left everybody else in. So really important to clearly communicate expectations, make sure that those expectations are realistic, given your honest and open assessment of your goals, strengths, weaknesses, etc., and your partner's honest assessment of their own goals, strengths, weaknesses, etc. Really very important to talk about what is and is not a deal breaker. We're going to talk about some of those things as we go forward today. Exclusivity, the term of the teaming agreement, what's included in the term and what's not. any non-competitive provisions that you have regarding, intellectual property or employees that are going to be working together. And again, I'll hit on some of those when we talk about the, drafting your teaming agreement and your joint venture agreement itself. But you really should be looking at all of these things and thinking, which situation is right for you. You need to think about it from a legal standpoint. So, in conjunction, talking to somebody like me, saying, all right, what are the legal ramifications of forming a team? What are the legal ramifications of forming a joint venture? What's the potential legal cost for drafting a teaming agreement versus, putting together a joint venture and going through that process. You also need to think about the business considerations, just as a realistic, what makes sense for my business, what would be the most beneficial. Let me do a cost benefit analysis and figure out what is going to get me where I want to go, and get me the experience that I want, and get me the resume that I want in terms of continuing to be a customer, I'm sorry, a contractor that does business with the government as a customer. You're going to want to think, specifically in terms of how you're setting up for each project. Which one is right for you? Do you feel comfortable being part of a joint venture and not being the prime contractor? Or would you rather be in a situation where you are the prime and everything is flowing through you? Issues of control, responsibility, liability, finances, those are all things that you should talk through with your, internally, talk through with your potential joint venture or teaming partner, talk through with your lawyer. Your partner should talk through with their lawyer, etc. You're going to want to think about affiliation issues. Affiliation is when the government deems two companies to be kind of related to each other, or controlled by each other, or controlled by a third party, such that for size purposes, those two companies, or sometimes more than two companies, are aggregated. What does that mean for you? It means that if you've got a company, company A, and there's company B out there, and you are deemed to be affiliated with company B, they're going to take however big you are, the government is going to take however big you are and however big B is, add it together, and then that's going to be what's compared to the applicable size standard. So affiliation can be problematic because it can push you over the size standard. It's generally easier to set up a team and, kind of go through, talk to your lawyer, figure out how to set up a team correctly, keep the companies separate but working together, and it's pretty easy to avoid affiliation. Joint ventures, that issue that I was talking about before in terms of using the mentor protege program as a prerequisite, joint ventures, it's a little bit trickier. You need to make sure that you do an analysis of whether the mentor protege program is required, and then you need to have certain things in your agreement to avoid the companies being deemed affiliated. And we'll talk about those when I get to the section on joint ventures. But all of these things are really important to keep in mind. Another really important thing that a lot of people forget to keep in mind is what solicitation, what projects, what type of projects, which IDIQ, which GWAC are you going after? And if it's already out in the street, look at the provisions. If it's not already out in the street, what can you anticipate the provisions are going to say, specifically with regard to the experience and past performance of a teaming partner? The reason that this is important is that the default rule is if you've got a joint venture, the government is required to consider the past performance of not only the joint venture, but of each of the joint venture parties. In other words, if you've got, limited past performance because you're a small business, your potential partner has a lot of past performance because they've been doing this for years and they're a large business. If you form a joint venture with that partner, the government's going to have to consider your past performance experience, your partner's past performance experience, and if the joint venture has actually done anything itself. All of that goes into the consideration when they're doing past performance analysis. If it's a team, it's possible that a solicitation could say, we're not going to give credit to past performance of teaming partners or major subcontractors, or they might say that they weight it not as heavily. So that's obviously going to change the calculus, right? Especially if the whole point of forming these types of teams, or or potentially looking into a joint venture, is to go after a project and have a competitive leg up. Very important to make sure that the way in which you're structuring your partnership is actually going to give you that leg up. And again, talk about all this up front. Make sure that you are aware of what your expectations are. Your partner's expectations are. Make sure they're aware of what your expectations are. Make sure that you honestly and openly discuss the deal breakers and are realistic in terms of what can and can't be done. Next slide, please. So let's say you go through that whole analysis and you decide that teaming is the way to go. Next slide. There are some kind of, overall common sense things that you should make sure that you keep in mind when working with another person. I think these are probably applicable to any relationship you have in life, but definitely applicable to business relationships and specifically to teams. The first bullet points: diligence and responsibility, ownership and accountability. Again, go back to any group project you've ever worked on. Nobody wants to feel like they're carrying the laboring oar and their partner isn't doing anything. Very important to do your share, very important to hold your partner accountable for doing their share. All the more reason why it makes a lot of sense to have discussions up front as to what the division of labor is going to be, both at the teaming agreement, bid and proposal planning, preparation, trying to get the job stage, and on the back end when you're talking about it. And then once we actually get the job and we enter into a subcontract, what are our expectations here? Again, open and honest communication, very, very important. Like any relationship, the more open and honest you are, the more transparent you are, the more you build trust. And then the more you're going to be able to work successfully together. And I will tell you, you're dealing with the federal government. They don't have a lot of patience for when parties, primes and subs start having disputes amongst themselves. It's not only going to build trust between, the teaming partners, it's going to build trust between the prime and the government, because you're going to do a better job performing your contract. You're going to get better CPARs. You're going to have a better relationship. You're going to look more mature and sophisticated to the government. It overall is just a good thing to have, a very professional, very honest, open and accountable system between you and your teaming partners. Next slide, please. So now we're going to get into some specifics in terms of what you really need to put into your teaming agreement. The first thing, and this is mostly for the benefit of the prime, of the small business. And again, since we're talking about, set aside, Judy, I think the slides seem to have closed out. Oh, there we go. Now they're back. Sorry about that, guys. So when you're talking about exclusivity, this is really for the benefit of the prime contractor, which in the set aside context is usually going to be is always going to be the small contractor. Remember, talking about set aside contracts, small contractors have the eligibility, so they're going to be the prime. The large company is going to be the sub. Obviously, you can also have a small company as your teaming partner or your sub, but most often it's going to be in these situations when you're going after the larger contract and you're doing it with your small business eligibility, small business prime, large business sub. So the idea is, remember that you as a small business, your partner is leveraging your eligibility. And what are you doing? Leveraging their capabilities, giving yourself a competitive leg up over the other small businesses that can also compete for this contract. What exclusivity means is that your partner can't go around and shop themselves around as a teaming partner to every single small or 8A or women to, as the case may be, other competitor you have. If they were to do that and they were the teaming partner for every single contractor, that doesn't give you a leg up. Everybody's got the same added benefit. Everybody's leveraging your teaming partner's capabilities. So one of the things that might be very important to you and might be one of those deal breakers that you want to talk about if you're a small business is exclusivity. The idea that your large business subcontractor can only enter into a teaming agreement with you, and they can't enter into a teaming agreement with any of your competitors for purpose of this procurement. Or if you're dealing with a GWAC or an IDIQ, that's a government-wide acquisition contract or an indefinite delivery, indefinite quantity, multiple award contract, whether that counts for every task order that could be issued under the contract, or, what the scope of the exclusivity is. If it's one of those multiple award contract situations, does that apply just to this year, just to a certain geographic area, or throughout the pendency of the whole contract, which could last for, up to 5 years, et cetera. Next slide, please. The other big issue that you want to talk about and think about and discuss with your lawyer when you're dealing with teaming is enforceability. The idea, if you remember, is that you enter into a teaming agreement, say, yep, we're going to work together to try to get the job. And if we get the job, then the prime is going to issue a subcontract to the sub. From the sub's point of view, what would be the worst case scenario that could happen, right? The idea is the sub, the large business, would never want a situation where they help you put a bid or a proposal together as a small business, and then once you get the contract, you don't give them a subcontract. Now, putting aside for this for a second that could also cause you problems with the government because you've now represented that someone's going to be performing or helping on the project and they're not going to be, that obviously causes a problem between the two potential teaming partners because now you're denying them a subcontract you promised them. So one of the major deal breakers from a subcontractor's point of view might be enforceability. The idea, hey, if you fail to turn around and give me a subcontract, I want to kind of, take you to court for breach of the teaming agreement, breach of the contract based on the teaming agreement, and say you have to give me a subcontract. This can be hard to do unless you are very, very specific and very deliberate in the drafting of your teaming agreement. The more specific language you can add, the better the chances that it's going to be deemed enforceable. The more specific you can be in terms of adding language like shall and must, the more the courts are going to say, okay, this indicates that the parties had an intent to absolutely, enter into a subcontract if the prime got the contract. And best practices from an enforceability standpoint, at least, is, if you've already got a subcontract drafted, obviously there's going to be some things that you can't have done or might be some things you can't have done until the actual contract drops. But to the extent you've already hashed out certain subcontract terms, attach a copy of the subcontract that you plan to enter into. As definite as you can make it seem that you're planning on entering into a subcontract, the better chance you're going to have that the courts would find it enforceable and that the sub would be able to say, no, I get my subcontract as long as you got your prime contract. Be aware that jurisdiction, and by that I mean which state you're in and which state laws you choose to govern your contract, your teaming agreement. When I say contract, I mean teaming agreement, could have a big difference. Those of you who are in Virginia, Virginia does not like teaming agreements. They do not like to find them enforceable. So again, an issue that you want to cover with your attorney, make sure you're picking the best state and choosing the best state laws to govern your specific situation. Next slide, please. Other than enforceability and exclusivity, which are two big things, two big potential deal breakers, one on behalf of this prime and one on behalf of the sub. The other things that I like to advise clients to think about are just all of the other expectations and all of the other essential provisions that, usually go into any sort of contract. With regard to teaming agreements in particular, it's very, very important to hash out term and termination and the scope. That goes hand in hand with what I was talking about in terms of especially exclusivity. How long are you guys teamed up for? Is it for this, or is it for 3 related projects, or is it for every task order that comes out under this multiple award contract? Only the task orders that come out in the next year, only the task orders that are in the Northeast. It's really going to be fact specific and it's going to depend on what you and your partner have agreed to do. And, again, with each partner talking to their attorney about what is advisable and how to make sure that that's codified in the teaming agreement. One thing that I think a lot of contractors forget about in teaming agreements is hashing out protest rights and responsibilities. Nobody wants to think about worst case scenario. Nobody wants to think about bid protests, right? But they happen. And if you're teamed up to go after a specific procurement, they can happen in one of two ways. You don't get the contract and you think you should have. In that scenario, who decides if you're going to file a protest? Maybe the large business is very used to filing bid protests, really doesn't have any hesitation about it, and really doesn't have any hesitation about spending the legal fees to file a bid protest. Meanwhile, the small contractor is the one that would have to file it. They're the prime. They're the one that would have to undertake, the actual action, go forward. It's their name that's going to be on the protest. So you want to make sure that you have an agreement ahead of time about what happens if one side wants or one party wants to protest and one party doesn't. How is that worked out? Who's got veto power? And who's paying the legal bills if it goes forward, etc. I have had clients who are subcontractors on major contracts come to me and say, we didn't get this, we got a debriefing, we think that we've got a right, but our prime sub teaming partner doesn't want to protest. And I say, did you put something in your teaming agreement? I didn't help you with that, or you did that without me, or you did that prior to hiring me. And if they don't have something in their teaming agreement, sometimes the answer is, well, I'm sorry, but you don't have the ability to protest. Only the prime can do that. You didn't put it in your teaming agreement. Specifically, the flip side, What if you're protested? What if you win and you're protested and the small business prime doesn't have the appetite to fight it or doesn't want to pay the money to intervene? Do you as a large business want to, protect that? Do you as a small business want to protect your right to veto spending those costs or being involved in that litigation? All things that you need to hash out. Other major things that you want to think about: protection of proprietary information. You're working together on a bid or a proposal. That might involve you sharing some information. That might involve your folks, the employees of the respective companies talking back and forth. You want to make sure that people aren't poaching information across these company boundaries. As you're working together, you want to share it for purposes of the bid or the proposal you're working on, or the scope of different bids and proposals that you're working on. You don't necessarily want to waive your right to your own intellectual property. Similarly speaking, your employees are going to be working closely together. You really don't want your teaming partner potentially saying, that's an impressive young lady or man. Let me take them and have them be part of my team rather than just working together on this one project that we're teaming on. Uh, you want to have NDA provisions. You want to have intellectual property protections. You want to have non-solicitation of employee protections. Again, remember, in terms of enforceability, the more exact you can be in terms of subcontract terms and what the ultimate subcontract agreement is going to be, the more enforceable it will be. And you want to think about governing law, especially to the extent that it could impact on enforceability, but it also could impact other things in terms of liability and costs and things like that. So, and in general, good advice for all situations: plan for all contingencies. Even worst case scenario, build that into your teaming agreement so that if something happens or if something goes wrong, you know how that will shake out between you and your teaming partner. Next slide, please. So sum up: best practice advice for teaming: discuss exclusivity upfront. That's a big thing that can be a deal breaker. Discuss enforceability upfront, another big deal breaker. And if you, agree that you want this to be an enforceable agreement, giving that subcontractor the protection that they probably want, you're going to be very specific and use very strong language: must, shall, with it, this shall happen within this many days type of language. You're going to want to agree on and describe the scopes of work. Sometimes it even makes sense to include a reference to the specific regulations like 13 CFR 125.6 that talk about how much work a prime contractor has to do, and that they're not going to overly subcontract more than they're supposed to subcontract. Plan for contingencies. And again, I know I'm harping on this, but I can't say it enough: open and honest communication, transparency, being realistic and being really communicative between the parties will make all of these things we talked about go a lot smoother and will result in a more successful relationship and more successful performance, and therefore better CPARs and a better track record with the government, thereby increasing your contracting opportunities going forward. Next slide, please. In terms of what can go wrong, I want to just quickly touch upon, the downsides of teaming. If you do it incorrectly, like I mentioned affiliation before. If you do a teaming relationship incorrectly, it can lead to affiliation. Affiliation can destroy your small business size status, hurt your eligibility. You could lose the contract. You could lose eligibility for future contracts. It could potentially be a violation of other regulations, result in bad consequences like sanctions, fees, debarment. Affiliation is the most common area in which problems arise, but also certain things involving control. If it seems like one company is controlling another, or if one company has ownership interest in another, these can complicate things. Generally speaking, these are pretty easy to suss out and to fix and to work around if you talk to a lawyer early in the process. If you wait to engage a lawyer until after the government has said, hey, there's problems with these things, and your eligibility is in danger, harder to, it's one of those stitch in time saves nine situations, harder to deal with it on the back end. But if you talk to a lawyer up front and say, look, this is what I'm thinking about doing for teaming. These are the other ties I have to this company. Let's, hash out whether or not there's any control issues. Pretty easy to plan around these things in a teaming context to make sure you're doing it in the right way and not getting yourself into trouble. Next slide, please. All right, so let's move on from teaming to joint ventures and the mentor protege program. So remember, joint ventures, a little bit different than teaming. Teaming is you still have two separate companies that are functioning, one is the prime contractor, one is the sub. Joint venture, those two companies come together, form a joint venture entity, and then the joint venture itself is the one that's going to be submitting proposals and being awarded a contract. So the first thing you need to do if you're thinking about joint venturing is you need to think about who's going to be in the joint venture. And remember the affiliation stuff that I talked about a little bit earlier in the presentation. The default rule for joint ventures is that you have, two companies. The joint venture is going to be deemed to be the size of the two companies put together. There are, however, two exceptions to that, two ways where you can make sure that the joint venture stays quote unquote small and furthermore potentially eligible for any other type of small business set aside like 8A, hub zone, SDVOSB, VOSB, WSB, EDWSB, etc. And that is number one, if both businesses are individually small. So in other words, if you're right under the size standard and your potential partner is right over the size standard, even though generally speaking, if you added your sizes together, it would push you over. For purposes of a joint venture, if you are each individually small, it doesn't matter how big you are in the aggregate, you can form a joint venture, and that joint venture can be a small business. And as long as you comply with the regulations dealing with, your, like, let's say your 8A eligibility or your partner's SDOSB eligibility, etc., you can set up the joint venture in such a way, working with an attorney who's familiar with the regulations, that your joint venture is small and eligible for set aside contracts. If, however, you are a small business or your partner is a small business and you or the partner is a large business, in other words, if you've got a joint venture involving one small company and a large company or some combination of companies like that, you need to go through the mentor protege process first. The only other exception to making sure that your joint venture remains small is if you are first approved through the mentor protege program. Next slide, please. So I want to jump over to the mentor protege program, and then we'll jump back to, once you've kind of checked that prerequisite, how you form a joint venture. So until very recently, there were two mentor protege programs. The old one that was around for forever was the 8A program. It was, as the name would imply, open to 8A companies and then their potential mentors. Several years ago, after many, many years of contractors requesting ever so faithfully from the SBA that they please, please, please expand this program. Those of us who are not 8A, but women owned or service disabled, veteran owned, or hub zone would also love a chance to participate in mentor protege programs, would also love a chance to form joint ventures and have them still be small, even if my joint venture partner is a large company. They set up, the government set up, the SBA set up what was called the all small or the universal mentor protege program. They have now combined those programs. It's just now at the all small regulation at 13 CFR 125.9. That is the regulation that kind of governs everything dealing with mentor protege, and obviously the moving pieces, like I said, and other pieces of the regulation that fit in. But that is the primary regulation that deals with the one, the only all small mentor protege program that deals with all small businesses now. The key thing to keep in mind when you are talking about mentor protege is the purpose of the program. And by that, I mean the purpose from the point of view of the SBA. And the purpose from the point of view of the SBA is really in the name. It's to provide mentoring services to small businesses. Yes, we are talking about it today because as a practical matter, many, many contractors use it as the prerequisite vehicle to form a joint venture and go after contracts. But the SBA has been very, very clear in that, yes, that is a benefit. But if that's the only benefit that's coming out of this, we don't want you to play. This needs to be a relationship that actually benefits the small business, that actually helps them grow, that actually provides mentoring services. It's not meant to be a vehicle just so large businesses can come in and quote unquote, air quotes, mentor a small business. And by that, form a joint venture and get a lot of revenue diverted their way as a subcontractor, as a joint venture partner. So a lot of the things we're going to talk about, especially if you see any tension between, what makes sense in real life and what the regulations require, it's because of the SBA's view of the purpose of this program. It's not set up to allow you to, just go form a joint venture. Yes, you can do that. And that's practically speaking why a lot of companies do. But from the SBA's point of view, that's not the sole reason. The sole reason is providing mentoring purposes, or, the main reason is providing mentoring services. Next slide, please. So The first thing you have to keep in mind is who can participate in the mentor protege program. If you are thinking about potential participation, you need to look at the eligibility requirements for mentors and for proteges. You need to talk to a lawyer about if you fit into these categories. We're not going to go into the nitty gritty today because it's so fact specific for each person. There's really no way to talk about general rules. It's something you need to talk about, with your PTAC, with your lawyer, and figure out what makes sense for you. But I will say that the biggest issues that come up here are whether or not either party has been involved in other mentor protege programs in the past. There are limits on how many times you can do this. And also the size of the protege, whether they're small for their primary NAICS code, whether they're planning on teaming up in that primary NAICS code, whether they're small for purposes of a secondary NAICS code. Those are the two major issues that can come up in terms of eligibility. But again, very fact specific, something for you to hash out with your attorney and your potential partner's attorney. Next slide, please. So the next thing you need to keep in mind is when you apply to be part of the mentor protege program, you need to put together an agreement, a mentor protege agreement, otherwise known as an MPA. There are templates online, including a template from the SBA. These regulations have changed recently. You need to be very, very careful about trusting even the SBA's own template. It wasn't even up to date on the last round of regs. It was mostly up to date, but lacked two of the required provisions that the regulations require you to have in your mentor protege agreement. I think it's always a good idea. It's a good place to start. Go in so that if you want to talk to your attorney, you've done your own research, you're well informed. You can kind of cross check that off of what your attorney or your legal professional says to you. Read the regulation, know what needs to be in the agreement, look at the template, take a shot at drafting the agreement between you and your partner, and then have your attorneys, your partner and your attorney's partner your partner's attorney look at it to make sure that you're meeting the requirements and to make sure that you're really hitting all of the things you need to hit. The biggest piece of the MPA agreement is the specific type of mentoring services that the mentor is going to provide. Again, remember, from the SBA's point of view, that's what this is all about. So the hunk, the big, the crux of the agreement is going to be showing what the small business thinks they need to do to be a better, more successful government contractor, and how across 5 or 6 categories, the mentor is going to help them achieve their goals. And this needs to be fairly detailed and specific. So that's really what needs to go into the mentor protege program, and your attorney can help you, attorneys such as myself. If you've got questions about this, feel free to reach out to me. Next slide, please. So once you put that written agreement together, you will submit it to the SBA. They will review and they will get back to you. It used to be, and again, like I said, these regulations change constantly. It used to be that you could apply for reconsideration. Not so much anymore. Now if they reject you, you need to wait another 6 months, or you need to try to apply with a different mentor or protege pair. Again, if you've got questions about this, it's something that you should talk about your specific fact situation with an attorney. But generally speaking, if you do it right the first time, you're going to be approved. It's not, that difficult as long as you keep everything in mind that I've been talking about. Next slide, please. So the other thing that's really important to keep in mind, and this is something that I like to talk about with my clients up front, is that once even if you get approved as part of the mentor protege program, yes, you can go on to form a joint venture. And we'll talk about that quickly before we, move on to questions. But the idea here is that that's not the end of the story as far as the mentor protege regulations go. Even if you are approved as a mentor protege pair, there are ongoing evaluation and ongoing reporting requirements. It is very, very important when you talk about that open and honest communication between partners and that talking about deal breakers, that the protege understands that they're going to need to be doing very specific reporting by hours and category of the mentoring services that they get. And obviously that implies that the mentor actually needs to be giving those hours of service. So once you get approved, keep in mind that for as many years and as many months and as many contracts as you perform together, there's going to be a lot of work on the back end. It's certainly worth it. If you're doing this correctly and you're using it to get jobs that can be very lucrative. But it's something you need to be aware of, and it's something that it makes sense to talk about at stage 1, because if you go through everything we just talked about and get to this stage and go, oh, well, I'm not willing to do that, or my partner's not willing to do that, you've just wasted all of the efforts of all the steps that we've already talked about. So very, very important to talk about upfront. If there's any changes to the mentor protege agreement or the scope of services or mentoring that the partners are going to be exchanging, you need to advise the SBA and get approval. There are really serious consequences of non-compliance, not being allowed to ever be a mentor or a protege again, violations and fines, loss of eligibility, even suspension and debarment. And in very extreme cases, that's rare, but that can happen. So again, really makes sense to make sure you understand and that you're doing this the right way, talking about your specific fact situation with a legal professional. Next slide, please. Now, why does anybody go through all of this? Well, because of the benefits you get. Obviously, we talked about the fact that it gets you around that affiliation issue, at least in terms of joint venture affiliation, but it also allows you to raise capital. The mentor can buy up to 40% of the protege company without really worrying about affiliation or control concerns the way you otherwise would. And then, of course, there is a lot of assistance that can be given within the scope of the mentor protege agreement. And that's going to be mostly shielded from findings of affiliation, which allows it, a much better, closer working relationship if you're a mentor and protege than you would otherwise have without risking some sort of affiliation or control type problem that could put your eligibility at risk. Now, one other thing before we move back to joint ventures and wrap up, that's really important to keep in mind is that it used to be a 3-and-2 rule that once you've got the joint venture set up, the joint venture could not perform more than 3 contracts in 2 years, or the partners would be deemed affiliated. It is now just a 2-year rule, meaning that once you go through all these steps and you set up a joint venture, that joint venture can only, be around, be performing and competing for new contracts 2 years from the date of their first contract award. So, keep that in mind. You are allowed to set up successive joint ventures, but after a certain number. And of course, the SBA is never really bright liney about their tests, so it's a little bit squishy. But the idea is, yes, you could probably set up 1, 2, maybe 3 joint ventures between you and your mentor protege, partner. But after that, you're going to be deemed affiliated. So keep in mind, this isn't like it goes for 10 years. This isn't it's indefinite thing. You will go through all these steps. You will get some great benefits, but it is of limited duration. Next slide, please. So best practices in terms of mentor protege, or I'm sorry, skip the slide. Once you go through the mentor protege process and get approved, we're back to remember that was a prerequisite to forming a joint venture. You need to talk to your lawyer. There are regulations about what needs to go in your joint venture provisions. There's about 19 provisions that need to go in there. The biggest thing you need to be aware of is if you're doing a mentor protege program, or I'm sorry, a mentor protege JV, the protege needs to perform 40% of the work that the joint venture is performing. Don't get that confused with the, the prime contractor subcontracting limitations of 13 CFR 125.6. They are separate and kind of overlapping requirements. In other words, let's say you've got a services contract. Many of you know, the prime contractor on a set aside services contract needs to perform 50% of the work, right? Remember, joint venture, unlike teaming, the joint venture is the prime. So the joint venture needs to perform or subcontract to a similarly situated entity 50% of the work. Of that 50%, if the joint venture is a mentor protege joint venture, the joint venture partner, that's the protege, needs to perform 40% of that 50%. It can get a little bit tricky. If you've got questions, again, talk to your lawyer, but you need to make sure that you understand that going forward, the protege is going to need to do that chunk of work. It's important. You're going to need to file certificates of compliance saying, hey, I understand the performance of work. I'm filing performance of work reports. Hey, we entered into a joint venture agreement that's consistent with the regulations. You need to make sure all your records are open and the SBA can examine them anytime that they want. And again, if you don't do this correctly, there can be pretty serious consequences in terms of your eligibility, but also fines, sanctions, and in very extreme cases where they think there was intentional fraud, which is rare because most of the time this is inadvertent mistakes, not intentional fraud. But there could be suspension and debarment. Like I said, this is all relating to quote unquote small joint ventures, but there are regulations similarly for 8A joint ventures, SDVOSB joint ventures. Each of them is going to kind of lay out the same framework. Here's what needs to go in the written agreement. Here's the 40% that the protege needs to perform. Here's how you have to do your certificates of compliance. Here's how you have to do your performance of work reports, et cetera, et cetera. It follows the same pattern. Next slide, please. So In conclusion, best practices for, joint ventures and mentor protege, but also obviously, as we said, with teaming, communication, communication, communication. I sound like a broken record, but there's a reason for that. I have seen so many of these relationships, and the partners that are honest and communicate with each other are the ones that it always works out for. The partners who are not, it doesn't go as well. Discuss options up front, be open, honest, transparent, really talk about your deal breakers, be realistic, understand all of the mentor protege and JV requirements. Like I talked about, the ongoing reporting requirements and the 40% performance rule. Talk with a lawyer, get the scoop, talk to your partner once you know the scoop, and make sure everyone is on the same page in terms of dotting I's and crossing T's and being willing to take this to the 100th step before you start step one. Otherwise, it's a waste of your time and a waste of your money and a waste of your efforts and resources. Make sure that it makes sense and that you're willing to do what you need to do to go the distance before you start down the path. Stay vigilant about requirements, including changes to regulations, client alerts, reading things that there are proposed changes to the rules. This is all important, talking to your lawyer. And the biggest thing is government contracting is a place where it takes a village, right? There are experts in accounting that deal with government contracts, government contractors in particular. There are lawyers like myself who's particularly focus on contractors that do business with the federal government. There are people like Judy that can help you with, other aspects of trying to, market your business, grow your business, really figure out what makes sense in terms of developing and expanding your business. Don't be afraid to ask for advice. This is a complicated area. Lots of people like to laugh it off like it's simple. As you, I'm sure, can tell by how much we covered today, it's not. There's a lot of moving pieces. A lot can go wrong with a silly, simple, small mistake. And it's really easy if you, do it early and do it right to avoid not only simple, small mistakes, but big mistakes. It's not hard to do this correctly as long as you ask for advice and go to the right people and do it right from the start. So don't be embarrassed to seek advice. Don't be, embarrassed to be honest about what you know and don't know. And don't be embarrassed to, share with your partner and have them share with you an assessment of their capabilities and your capabilities and what makes the most sense for you. All of that is really important if you want to succeed, both in the relationship and then in the performance of the contract. So with that, I will turn it over to Judy. I know we got questions while I was going. So I will stick around a little bit more and we can talk, about questions. If you've got questions that we didn't get to, you can feel free to reach out to me directly. You've got my information on the screen. You can call me, email me, or connect with me on social media. You've got my Twitter and LinkedIn information as well.
Maria, that's fabulous. So I know we did get some great questions. We're going to relay a few of them. Heather, if you would drop Maria's contact information in the chat, and I think you probably just did that, to just make it easy for folks to reach Maria. We have some bonus material for you I'm going to cover, and we'll circle back. Maria said she has a few minutes and can stay for some questions, and we have some great ones coming up. So, Maria, thank you for your generosity in so many ways. Again, we give these webinars and we love to know the best way to do those. If you haven't yet answered the poll, I hope you'll do that. Give us a better idea of what direction to go and what's important to you. We're going to get to questions and answers. I'm going to pick one off the top right away. And hang on a second here. Susan wanted to know, do you know anything about the VA healthcare furniture IDIQ? We had 2 of the VA designers we reached out to telling us they can only buy signage under the VHA furniture IDIQ. There are only 8 of these companies. Should we team or should we sub? How would somebody answer that question, Maria, based on the distinction you made between teaming and subcontracting?
So I think there's a lot of things that play into that. There are certain restrictions in terms of, eligibility. When you get into being a vendor, it's also a little bit different in terms of who can be a manufacturer and who can sell things and who can be approved, especially when you're dealing with the VA because they have additional requirements. It's hard to weigh in on in a vacuum on what would be a better strategy. Number one, because like I said, a lot of it is factually dependent on what's best for you and what suits your goals and whatever the partner that you're looking to team up with or joint venture up with goals are. Where you should start is talking to a lawyer and having them look at the solicitation or look at the opportunities that you're trying to go after, because there's going to be stuff in that solicitation that may impact what makes more sense and what the requirements are in terms of who it makes sense to team with or joint venture with, and how it makes sense to set up that relationship. But that's not really something that, can be answered without understanding either A, what's in the solicitation, or B, what you're hoping to accomplish and what potentially, a partner of yours would be hoping to accomplish.
Got it. All right. Real quick, we've got a bunch of resources for you. We're going to cover those and come right back to some of the questions that you have. If we don't get to your question, please contact Maria. You can see that everyone's situation is unique, and she's generously offered to talk to you without, oh my goodness, we're running the clock. So Maria, thank you again for being willing to do that. If you want to know what's next for you, and I want to cover this just before we get to the top of the hour, is find the right buyers, get in front of them, stay in front of them if you want to win. Watch for a follow-up email that will have not only the link to this recording, but also the links to all the resources that we're going to talk about right now. And the links to those are in the chat. Want to know, drop in the chat, what one thing do you commit to doing today based on what you've learned, which is a whole lot. So please drop that in the chat. I would really like to see how we made a difference for you. What's your aha, the big thing that you learned from our time today? We'll share some of those. So we covered a lot. Differences between teaming, joint venturing, mentor protege, and how they fit together. Differences between subcontracting and teaming. Strategies for successful teaming. Most important provisions in a teaming agreement. Enforceability expectations and exclusivity. What can go wrong and some negative consequences, and how to avoid common pitfalls. This was fantastic, Maria. So again, drop a response to the poll. We'd really appreciate it. And here are the resources that can help you. First of all, we have a complimentary infographic, the 5 people you need to meet. Every place you want to be successful, whether you say, oh, I'm just going to team or I'm just going to subcontractor, I want a prime, you still need to know who the 5 people are, have relationships with the players at all 5 layers. And so the infographic tells you at a glance. You can check them off and say, hey, do I know these people or am I missing some? And you can link at the bottom to our 22-page GovCon Personas Guide. This really unpacks the players at all the layers. People you're going to need to know if you want to team successfully, because your teaming partners, if you're going to be a junior partner or subcontractor, expect that you're going to bring business and contacts and relationships to them. And so this is really going to help you position yourself for effective teaming and being a stronger partner. GovCon Personas Guide. As well, the flagship program that we work on with our clients is the Federal Business Intensive. If you want to find out more about what you can accomplish in 8 weeks or less, building a solid relationship pipeline in at least 3 places where you're confident you can win work, this is what we do. I'd love for you to figure out whether or not it's right for you, and then let's have a conversation about it. So you can get the details at that link. Coming up, how to give your federal buyer what they want at federal fiscal year end. That's going to come up. We're going to be talking about that on August 26th. Register and grab your seat now. We've got resources for you, free resources on my website, including great meaty blog posts, on-demand webinars, upcoming events, book and a workbook. Take a look at that webpage and tap what's going to help you right now, today. Are we a fit to work together? Let's find out. Use that link, book a chat. Let's pick up the conversation. And with that, then, we're going to go back to questions and answers. We've got a few of them. And so here we go. Hang on a second. And there we go. Let's see. Here's, if you're a small business in a mentor protege agreement with a large company and you team on a GSA contract, do sales count toward your annual GSA sales requirement?
So again, that's going to be fact specific, and this should not be construed as legal advice to your specific situation, because I don't know the ins and outs of your contract. But the general rule is, when you are in a joint venture performing the percentage that you own the joint venture, that's going to be credited back to you as your numbers. If it's under a GSA contract, that most likely is going to be the case. If you're teaming, it's only going to if you're the prime, it's going to count for your own numbers to the extent that it would if you're the prime. If you're a sub and you're getting a portion of that money kind of flowed down to you, then that's the number that would count. And again, I know that kind of sounds like half and half rationale
It's
there, but again,
complicated.
it's hard to answer these questions without knowing your specific situation and your specific contract and what contract you're talking about, because there's no one size fits all rule, unfortunately.
Got it. I had a great question from Karen who wanted to know if our company, a woman-owned small business, joint ventured with a service disabled veteran-owned small business, which set aside would prevail?
That's an excellent question. And let me kind of attack that by taking the converse. You need to decide which kind of joint venture you want, or if you want multiple. And that is because in order to have a joint venture that is set up as a WSB company has to own 51% or more. If you want a joint venture to be set up as an SDVOSB company needs to own 51% or more. So if you set it up with your WSB, a 51% owner, you wouldn't be able to make that joint venture eligible as an SDVOSB and then vice versa. So you would need to figure out, do we want to joint venture to go after SDVOSB contracts? In which case the SDVOSB needs to be the managing member of the joint venture and own 51%. If you wanted to use it to mostly go after WSB contracts or to go after WSB contracts, you'd need to set it up with you, the 51% owner. Now, that's not to say you couldn't set up two different joint ventures.
That was my question. You read my mind.
Yeah. But again, you need to be careful about, how long you keep doing that and what other ties you might have between the two companies, such that such prolonged interrelation might lead to an affiliation or control problem.
Mhm.
But again, it really kind of demonstrates how the strategies you use and how you set these things up are really tied to the opportunities that you're specifically trying to pursue with your partner.
Fantastic. We are coming close to out of time. Maria, I want to thank you so much for your incredible generosity. I learned a lot. I hope others did as well. The kinds of things that people said they are going to do as a result of being here is to check the joint venture we have in place, explore further joint ventures, big time explore the big aha was the time limit on joint ventures, continue being visible to potential buyers, outline what resources, outline what if scenarios and how we'd handle them with the new joint venture we're about to enter. Someone else said finding a good attorney to work with. Yes, we had a couple of people say, hey, where can I find a template for a joint venture agreement? And tell me if you agree with me, Maria. The answer is that there's no template that's going to be just right for your company. Joint venturing is not a do-it-yourself game. And so while you could read them, come with your set of ideas and engage an attorney to help you put together something that's going to be right for you and protect your interests. Sound right?
Absolutely. Yeah. And you actually, specifically with joint ventures, you need to be really wary of the templates you find online, because not all are for government contractors, which mean that they have provisions that can be problematic for any size government contractor. Then even the ones you find for government contracting aren't all for small contractors. And even the ones you find for small contractors might be the, last year's regs or 3 years ago's regs, or, as stuff on the online always could be, someone who doesn't know what they're talking about anyway. So the best place to start is the regs, is to go to the regulations and read what they say about joint ventures in your particular area, and then to talk to an attorney. There is a wealth of information on the SBA's website. Start there, use that to find the regs, and then go after you look at the regs and talk to an attorney about what your goals are, and they can help you put together a template that you can use at least once and possibly tweak to use future times if the situation warrants.
Wonderful. Maria, thank you. Summit Insight is a professional services company. We work with established companies that have been in the market and are looking to get to the next level of wins. I would love to chat with you to explore whether we're a fit to do that. Maria, thank you for your generosity. We encourage people to follow up. We're going to share your contact information in the follow-up email. You'll get a copy of that follow-up email, the recording, and all the links to the things we talked about. We'll see you next month. Thank you so very, very much for being here, for sharing your questions. The recording will be attached, and we're so glad you're able to join us today. Thank you so much.